It seemed to me that you think I should reconsider my decision because another judge felt differently.
Morning, Your Honor. Eric Pepperman for plaintiffs.
Morning, Your Honor. Martin Little for NSF International.
Morning, Your Honor. David Spurlock, United Natural Foods.
Good morning, Your Honor. Daniela LaBounty on behalf of Defendant Costco.
Good morning, Your Honor. Scott Rasmussen on behalf of Hand Instruments, SID International, and SID US.
Good morning, Your Honor. Nathaniel Carlson for Defendants, Real Water Inc. and AffinityLifestyles.com Inc.
And Your Honor, Colt Dodd, Real Bar 9000 on behalf of Nevada Beverage.
Morning, Your Honor. Cindy Hernandez on behalf of Winco Foods, bar number 7218.
That's
it, Your Honor.
okay, great. All right, we are here on plaintiff's motion for reconsideration of my July 6, 2023 order granting defendant NSF International's motion to dismiss. Mr. Pepperman, it seemed to me that you think I should reconsider my decision because another judge felt differently in 4 of the other cases that are coordinated with this matter.
No, Your Honor, that's not the basis for the motion. I do think that is something that the court should know and is a potentially relevant consideration for Your Honor, but I understand the court's not bound by the findings or the rulings of other judges. The basis for the motion is that this court's dismissal is premised on the notion that NSF owed no legal duty as a matter of law. I respectfully submit that that's a conclusion that warrants reconsideration. The complaint alleges a voluntary undertaking by NSF to perform inspection services. And as we lay out in the motion, under Nevada law, NSF had a duty to exercise reasonable care in the performance of its undertaking. That's the Dow Chemical v. Malum case, and that's applying and adopting the Restatement of Tort Second, Section 324A. The court's order is based and cites the rule in Sanchez v. Walmart, but it does not address the legal duty in a voluntary undertaking case, which is what we believe applies here. We respectfully submit that the plaintiff's complaint gives fair notice of the legally viable claim of a negligent voluntary undertaking, and that the factual issues raised by NSF are not waived. Those are just a matter of discovery, and if there's a basis for summary judgment upon that discovery down the road, then NSF is surely entitled to make that motion at the right time. But dismissal precludes. To that end, I do think it's important to point out that this is one case of many coordinated real water cases, and NSF has been sued in 6 of those cases. And NSF, the complaints in all 6 cases are identical, same allegations, same substantive allegations, same basis for the claim that NSF is alleged to be liable for. NSF filed the exact same motions to dismiss in all 6 cases, and in the other 5 cases, the claims were allowed to proceed past the dismissal stage. I do think it's a relevant consideration that we have identical claims, identical allegations, identical motions to dismiss, and 5 of the cases are going forward. I think that's important because, not because this judge is bound by the other court's decisions, but those cases are coordinated with this case, and NSF is going to be in those cases, and we're going to be doing discovery on the exact same claims as in this case. So from that perspective, there's no material difference to NSF. They're still going to be engaged in the same exact discovery, the same exact claims. So I do think that's something for the court to consider, especially with respect to our request for alternative relief in the motion for reconsideration. Because while I do believe that the complaint sufficiently alleges a voluntary undertaking duty and that it is sufficient as pled, if the court still has concerns over that, I do think that leave to amend would be appropriate as opposed to dismissal, to give plaintiffs the opportunity to allege factual details that I think would, I think we would be able to allege facts that would be acceptable to the court in a ruling on the motion to dismiss. The order is very specific that the concern by the court is that the complaint fails to allege facts to establish a duty or fails to allege facts that would establish the claim. So I think before we're denied the opportunity to pursue the claim as a matter of law, the opportunity for leave to amend would be appropriate. I don't think it's necessary, but if the court still has concerns over the voluntary undertaking issue, we would ask in the alternative of reconsideration and denying the motion, you reconsider and at least give us the opportunity for leave to amend.
Okay, Mr. Pepperman, the one problem I've got with your request for alternative relief is that I think you need to file a separate motion and attach a proposed amended complaint. That's required under the local rule of practice. I can't just take a sentence out of your motion for reconsideration and say, which says basically in the alternative we want to amend our complaint. You know, the EDCR 2.30 specifically requires that you provide me a proposed amendment. And also, it's got to be attached so that the other side knows where you're going. So, okay, does any of the other attorneys in Blue Jeans Land or Mr. Spurlock, do you want to address this before I talk with Mr. Little?
No, Your Honor.
Okay, I'm not hearing anything. Mr. Little.
Thank you, Your Honor. Happy to answer any questions or concerns that the court has. I obviously don't want to sit here and regurgitate all of the arguments I made at the motion to dismiss hearing, but that's precisely what Mr. Pepperman is doing and the plaintiffs are doing in this case. They're re-arguing the same facts and the same case law that they presented to you at the motion to dismiss hearing, including case law and the Good Samaritan law in Nevada. They don't point to any intervening changes in the law, and that's because there are none. They don't point to any new facts or evidence, and that's because there are none. And respectfully, I think that they are really just sort of in a due fashion trying to get you to reconsider your decision because Judges Escobar and Kishner ruled differently under similar facts, but that's not a basis for reconsideration. You're bound by those decisions, and importantly, neither of those judges found that there was a duty owed by law or that there was proximate cause. Rather, they simply punted and said that they weren't going to make any dispositive rulings at that stage, at the motion to dismiss stage. They never said, hey, we think this case fits under the Good Samaritan law, there's a duty owed by NSF International, or we think that there's proximate cause. They didn't say that. They just punted. They said, we're not going to deal with it at this stage. So I don't think that ruling, it's two judges, the rulings by those two judges have any impact on this court's decision. As you know, motions for reconsideration are only granted in rare circumstances where you have new issues of fact non-existent or intervening changes in the law. Those don't apply here. Or where they can show that your decision is clearly erroneous, and they haven't done that. They're regurgitating the same arguments that they made before. So I don't think that they've met their burden. The only other issue, I guess, to address is leave to amend. What I would point out on that is when they filed their motion and argued in court before you, they never raised an issue like wanting to seek leave to amend depending on the outcome of this court's ruling. As you pointed out, they never filed a motion. We don't have any proposed pleadings, so I think that that's only inappropriate. Thank you.
Okay. What about their position that, well, we've got a coordination of all these cases? In fact, I think there's 15 of them, that we've had 5 decisions that went against, well, that I rule differently in those than the judges in those cases, and that your client's not going to suffer any prejudice anyway because you're going to be there.
I mean, I don't agree with that because this is a separate trial. So, I mean, we are going to have a separate trial for this case. And I don't follow the logic of that. These are individual plaintiffs. They have their own set of facts. Yes, they're coordinated for purposes of discovery, but those particular plaintiffs have different set of facts. I don't know if these particular plaintiffs purchased from Costco, didn't purchase from Costco, did they buy the 5-gallon jugs, the bottles, that they get it from the Henderson facility, a different facility. There's a lot of factual issues here, so I'm not following that logic. I don't think that.
Okay. Do you see this case being consolidated?
So far, no. I don't. They're going to trial in September in a different case that doesn't involve NSF. So.
Let's see. We don't have a trial date yet because this is, I guess, a relatively new case. Okay. Anybody? Pepperman, you get to reply. It's your motion.
Yes, Your Honor. Just to clarify, this case is coordinated with the other real water cases for discovery. And that's what we're talking about. We're here on a motion to dismiss or a reconsideration of a motion to dismiss. This is just
what are you doing?
We state a potentially viable claim against NSF to pursue discovery on. Like Mr. Little mentioned, the other judges, they didn't validate our claim. They didn't say they're liable or that there's a duty that is going to apply based on the facts or that there's causation or anything to that. They just said, you've alleged a voluntary undertaking case or a negligence claim. There's a potential viable claim and you're allowed to pursue discovery to that end. And that's all we're asking here is just the opportunity to pursue discovery on this claim, and any factual problems with the claim that come based on that discovery. I have full confidence in Mr. Little to raise those issues with the court. But in terms of whether we're entitled to pursue our claim, based on the allegations in the complaint and under the rigorous standard of a motion to dismiss, which all reasonable inferences are drawn in our favor, all alleged facts are assumed true. We have met those requirements in the complaint, I believe, as alleged under clear Nevada law involving a voluntary undertaking. I mean, it's really not much more than you voluntarily undertook to perform these services, and you perform those services negligently. That is a legally sufficient claim. That's a fair notice of a claim that we shouldn't have dismissed. If there's any concerns about that, I do think that leave to amend would be appropriate. I think that if I'm filing a motion to amend, you attach the proposed amended complaint for the purpose of giving the opposing party the opportunity to respond to the motion and say, well, no, it would be futile because this claim fails to state the amendment fails to state a claim. That is essentially the motion to dismiss. So in this scenario, the reason we didn't attach an amended complaint, a proposed amended complaint, is because respectfully, we think the complaint alleges a valid claim as is. The only alternative question is if the court has any disagreements with that, do we get the opportunity to try again? In which case, we would file the amended complaint under the court's leave and Mr. Little will have the opportunity to move to dismiss. So the fact that we haven't drafted the amended complaint yet, that we don't think we really need to draft or submitted it or have gotten there, I don't think is a defense to giving us that opportunity. So in sum, we think reconsideration is appropriate because we allege a voluntary undertaking negligent claim. That's a legal duty. The court did not address that. The court in its order did not say why that we failed to allege a voluntary undertaking. So that is a basis for reconsideration. We don't need new law from the Supreme Court to ask for that reconsideration on that basis. And if the court has any concerns remaining about the factual allegations, we respectfully request the opportunity to address and cure those concerns.
Mr. Pepperman, the discovery that you're going to do with respect to NSF in those other cases, they're going to be basically the same. Even if NSF is not here with respect to the Way case, you're still going to be able to do the discovery that you would need, right? If by chance you say, hey, this discovery I've just done really indicates that NSF should be a party here. You would have all that information, right?
Yes, the discovery is going to be the same. Yes, we're not going to take the same NSF depositions 6 different times in 6 different cases or 5 different times in 5 different cases. So yes, the discovery would be the same and we will have that information. Whether we apply it to NSF in this case is dependent on whether they're a party in the case. So, we think that they're going to be there anyways. They're going to be doing the same discovery. And if it applies in one case, it should apply in all the cases. If it doesn't apply in one case, it shouldn't apply in all the cases. That should be based on the facts and discovery that's done, and NSF will be able to challenge that at the end based on with the summary judgment if it's appropriate.
Counsel, I'm going to tell you this, that whenever I read through the complaint and the allegations set forth in the 9th claim for relief, I reviewed it pretty carefully, and I didn't think it stated enough. We've got NSF that has been contracted to look at a facility and inspect a facility, and their duty was based upon contract with the other contracting party. And I don't see the connection between inspecting a facility with, in fact, at one point in reviewing your motion, it was that they were charged to inspect real water, and that's not what they were charged with. They were charged with inspecting the facility. And I just don't see the causal connection between any breach of that. So for that reason, I think I got it right. So I'm denying your motion for reconsideration. If you are interested in filing a motion to amend complaint to incorporate maybe different facts or showing me the connection, showing me that there was a duty to the consumer, then fine, I will entertain it. I'm here to try and get this right, but just because 2 other judges ruled differently, and maybe I'm the maverick here, but that's just not going to sway me. So I am denying the motion for reconsideration. Mr. Little, will you compile the proposed order?
I will, Your Honor. Thank you.
All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor.